Zulu versus the President of the Republic of South Africa and others.
Thank you. My Lord, I only deal with the first Judicata. And then the friends will deal with the rest. But in the course of making my presentation on the res judicata point, if your Lordship has questions that may overlap into Smelane's terrain, I have unrestrained duty to answer the court, so I will deal with those that come from the bench. At the start, my Lord, can I just make this one submission which I believe has no contest. The President cannot rely on res judicata. You will see and find nowhere in his reasons for recognizing Mrs. Zulu, for recognizing the second respondent as on the basis that on the basis of res judicata. In other words, that the issues in court had come to a finality. In fact, in his own papers, he accepts that. The President, he accepts that there was an application for leave to appeal. When at the time he made the decision, there wasn't. But he accepts that he'd been told that the royal family intended to appeal, and he made the decision knowing fully well that that was going to be happening. But there is no as you know, the defense of res judicata was raised by the second respondent and not the President. And for the President's decision, he has to specifically explain how res judicata influenced how he comes to the conclusion that the jurisdictional requirements of Section 8 have been met. And our submission is that the President couldn't have relied on res judicata. It doesn't say so in his papers that res judicata was a point. We understand he relies on Justice Madondo, but not for purposes of of relying on the principle of res judicata. It may have that. The reliance may well imply that he's relying on res judicata, but we say that is not what influenced his decision. So the res judicata point is not there. But more importantly, my Lord, the res judicata principle cannot operate to the disadvantage of parties. If the idea is to disentitle the royal family from resolving its fundamental dispute that sits at the core of the identity of the kingdom, then that principle ought to be bended in order not to prejudice people who are directly affected by what this principle is intended to do. So I would say that, Your Lordship, in considering whether res judicata applies, must consider whether it is being activated in an oppressive manner, in a manner that disentitles an ancient right, as I explained on Monday when I made my representations. Going to the judge, returning to the judgment, my Lord, I want to start off by saying the following. I'll rely firstly on paragraph 102 of the judgment of His Lordship, Justice Madondo. It's paragraph 102. And my Lord, I don't have the case line reference, so I saw that you did have that, so I was comforted by that. My Lord, if you look at what paragraph 102 says, the paragraph 102 says there is accordingly no basis for interdicting the process leading to the recognition and coronation of Prince Misuzulu. The Premier or the President, as the organ of state that has not yet acted, which could justify an approach to the court for a review, if it were to be sought. Had the applicant sought a review of the identification, their application would have been solely dismissed on the basis that it was premature. The nomination and appointment of Prince Misuzulu as the successor to the throne and king of the Zulu nation, in terms of the wishes of the late queen in her will, has been subsumed by the decision of the royal family identifying and nominating him as the king of the Zulu nation. The royal family has the responsibility, as a prerogative to identify and nominate traditional leadership. What is important about that paragraph, my lord, is that we are now in a review process, which Justice Madondo acknowledges was not what he was dealing with. And it's important what the nature of these proceedings, why res judicata is uniquely unsuited to be used as a principle to resolve this particular dispute. In a review application, what your Lordship now has is a complete picture of what happened. In other words, your Lordship has more than what Justice Madondo had when he made the decision that he made. He has got, in this courtroom, my lord, you've got now the Rule 53 record. You've got a bit more details about what took place on the 14th of May 2021. You've got the mediation ad hoc mediation panel report. Justice Madondo didn't have that. If you go through the mediation report, you'll see that a lot is recorded of how the royal family saw the dispute. And it could never be suggested that the 14th of, sorry, my lord, it could never be suggested that the matter got resolved on the 14th of May 2021 because Justice Madondo says so. You'll see that Justice Madondo say a finding on the meeting of the 14th May is simply that the 14th of May has not been challenged. In other words, people who appeared before him at the time did not specifically raise the 14th of May. Well, they did raise the questions about the 14th of May, but the main issue really was not the issue as you are dealing with it now. What you are looking at now, my lord, is, and this is why I started off by saying what the case is not about. The case now is about whether the president acted lawfully, not about who should be king or who has got a better title and all that. And in assessing whether the president acted lawfully, your lordship has to look at the information you now have, complete picture of the circumstances around the meeting of the 14th of May, and ask yourself, my lord, whether or not Justice Madondo would have been justified to hold this view if this were a review application. So you've got more evidence than what Justice Madondo had, because this is a review application. No, it wasn't. And one of them, my lord, is you have to have the mediation report, the process that the president triggered in order to investigate circumstances that resulted in the meeting of the 14th. Because that's exactly what the president was saying. The president was saying, okay, there's now this dispute in the royal family about the meeting of the 14th or the identity. Advise me on it. That's what he says to the minister. It does say that in part, yes.
And then the president says, well, I've waited until it was finished, and now I saw what an acting president of that division had said.
Yes, that's correct. But here is the catch, my lord. If you look at the mediation report, it specifically says it appears that the meeting of the 14th of May was not done in accordance with the law. And if your lordship wishes me to point you to exactly the paragraph where that mediation report. Yes. No, so before Justice Madondo there was no mediation report. So Justice Madondo doesn't. Which they did, my lord. Yes, that is why we criticize the judgment of Matondo for that, exactly that reason. That what Justice Matondo does is that he goes into the succession issue in detail, when that issue was really not a crystallized issue in the sense that we have it now here. In other words, what he was being. No, but my lord, no, not exactly. Which you can't do, yes. But what we're saying, there are two proceedings. The first proceedings in Matondo is an interdict. So what Justice Matondo deals with is what is before him. And you will see, my lord, that you've got better information, better evidence, which never served before Matondo in order to explore whether or not the meeting of the 14th was in self-compliant with customary law. In fact, no, but my lord, let's go to that part in the judgment. He was part of the litigation. That is correct. This is how my client at the time was advised to enter the proceedings. Firstly, it starts at paragraph 67 of the judgment. The part that is important, pending the final determination of applications under 2751, 2021P, and 2752, 2021P. So it says pending that, wait. Because the dispute there is about the will. The royal family takes the view that the will is relevant for how they consider the issue of a successor. That issue is important for them. So the royal, on behalf of the royal family, they say, well, resolve that. Let's wait until that issue is resolved before we can do anything. Of course, the coronation was not taking place on the 3rd of December, and of course the matter was dismissed on a number of bases. But amongst those is that the applicant in that case had no standing, which is quite, frankly put, extraordinary. To say the most senior member of the Zulu royal family has no entitlement, has no local standing to challenge an identification process. My lord. Can I just 001-8. Yes, no, I drew the application, but I know. It's, that's correct, my lord. That's correct, my lord. No.
and the JP finds X, you say, well, you know, 18 months later I go to a different court, I produce more evidence, and say I want you to decide the same question.
No, so, my lord, if you go to paragraph 91, in the middle of towards the end of that paragraph, it says, the judgment says, no, sorry, maybe the identification of a traditional leader, successor, is only the initial part of the administrative action.
You say that paragraph says, in this application, the applicant does not seek to review the identification.
Yes,
Rather seeks
yes,
to review
yes,
the question of whether the methodological review does not provide.
right. So there was never, so before, and I think what really happened was that the issue was raised in answer by Prince Buthelezi, that this issue of identification is critical, and you'll see in one of the paragraphs of Justice Madondo where he says that Prince Buthelezi said, if this is not resolved, it could create a war, if you want to put it that way. So I'm saying what really happened was that while the issues by the applicants in that case did touch on succession, there was no thought given into how to frame the case in an interdict application. In other words, even though they raised the issue of the succession issue, even though they raised the succession issue, there was no a frontal attack, let's put it that way, and that's what Justice Madondo says. There is no frontal attack on the meeting of the 14th of May. There is no review of that decision, precisely because the approach of the applicants in that case was to not challenge, as he puts it there, not to bring a review. It was simply to to stop the proceedings from, to stop the process from going ahead at the pace that it was. And I'm suggesting, my lord, that the issue of review, right?
Why?
Because the royal family was still in a stage where it was not ready to deal with the process of succession, and not as far as the royal family is concerned, as we define the royal family. No, my lord, no, my lord, this is what Justice Madondo says. Justice Madondo defines what Prince Mbonisi says. Prince Mbonisi says there is a dispute about the will, there's a dispute about the status of the marriage, there's a dispute that impacts on how the royal family decides, engages with the issues of who the successor should be. No, because that was not intended to be a dispute before that courtroom. And he's correct, because that was not intended to be a dispute in that courtroom. Yes, yes. And I'm saying, my lord, and in fact it does reflect in paragraph 102, where he says, you know, if they brought a review application to review the recognition decision, they would have been thrown out at the time. Because you await the process to go until the recognition is done, and then you bring a review application. On the same logic, what they're trying to do with activating the res judicata point is to stop, basically disentitle the royal family from ever dealing with this matter again. That wouldn't be fair. That would be an abuse of the principle of res judicata. Yes. So, my lord, what your lordship now has, volume and volume of paper from different members of the royal family, telling your lordship about the meeting of the 14th and other aspects of the recognition process that they believe was not fair. which is not what Justice Matondo was dealing with at the time. He was not dealing with the review application. He was not engaging with whether or not the meetings were procedurally fair or anything like that. He made those findings, that's true. But we say that was not a pertinent issue before him to have made a far-reaching remark as he did.
Do you remember the case from also from the first time?
Yes,
Also refusing it almost on the basis of finding counsellors, exercising discretion, and almost an absolution from the end.
yes.
In this case, it's not really distinguished because my older ASP didn't say, look, you didn't have a prima facie case or the grounds of convenience, let the president refuse to come on review. He said, let me see if you have any right to challenge the decision. And then he made his finding.
Yes.
It is different from the case before her.
No. But here is the issue in Justice Matondo is that the manner in which the parties wanted the matters resolved on an urgent basis was to stop the process from going ahead. So in order for the nature of the proceedings themselves were such that there couldn't have been all the information that is required in order to decide the question of whether or not the process has been lawfully followed. What we are here, my lord, is to say is saying, look at the president's decision and then walk backwards and ask yourself, has the president acted in a way that is lawful? And the answer to that, as far as we're concerned, is that the president has acted unlawfully by recognizing the second respondent as the king. Precisely because if one locates the decision-making process of who the successor is in the royal family, these members of the royal family are contesting exactly that. And Justice Matondo, in his judgment, says, no, in this matter, there was no frontal attack on the 14th of May. So I'm assuming on the Plascon events or on the rules that he applied, the meeting of the 14th is untouched. And then he makes determinations based on that logic, that because that meeting had not frontally been attacked, it was therefore incumbent upon him to make further findings based on his acceptance that meeting had not been frontally attacked. It's different. Here, it's frontally attacked, and it's based on a Rule 53 record. And the Rule 53 tells us a bit more about what exactly was before the president, before he made this decision. But, my lord, there is a when one applies this res judicata principle, it's got to be fair to the parties. I make that point because the next issue that your lordship must deal with is where I started on Monday. This matter is about whether the president acted lawfully. It is not about, we can talk about the meeting of the 14th and all that, but when the president looked at the meeting of the 14th, was he persuaded that all the members of the royal family were there? When he examined the meeting of the 14th as the decision maker who was about to recognize the second respondent as a king, did he look at the meeting of the 14th and was convinced on his own? For a moment, park what Justice Matondo says, because Justice Matondo does not have the full picture that the president has, having conducted the mediation process that has captured a bit more about the meeting of the 14th. He doesn't have that. And bearing in mind, too, that in his courtroom is not a frontal attack of the 14th of May. So he has an easier job. He doesn't even have to look for evidence, because if the 14th of May is not attacked, he doesn't have to look for evidence that now the president has when he looks at what the mediation committee says. And the mediation committee specifically, and it's very important that the mediation committee says the 14th of May wasn't exactly compliant with the law. That was not before Justice Matondo. It is before your lordship. And given that these are review proceedings, and the review proceedings are targeted at the decision maker who has placed the royal family in this position, the president. So, my lord, this court has got wider evidence, more evidence than when Justice Matondo made. There is a frontal attack on the meeting of the 14th than there was at the time. So the royal family before Matondo did say that the meeting was not properly constituted. It was not, the members of the royal family were not there, and all those complaints.
The attack then is, as you said, on the conduct of the president and the recognition decision. What must the court then do with the finding of a Matondo HAP then that there was no sufficient dispute raised at that time? And there's a finding of no sufficient dispute that the Prince is guilty, and was more just about who was chosen, not the process. Therefore, it didn't qualify for Section 84. That's what he said as well. And now he makes a finding. On what basis can one then attack the president? He says, well, I have the evidence. I consider it. I even have a mediation procedure. I have a minister advised on the letters. And here I have a judgment that says, look, there's no proper dispute. 84. I need not conduct or appoint a committee constructed as it is in terms of the act to investigate it. It is urgently incumbent upon me then to take a litigation decision.
Yes. Mercifully, it doesn't say that in his own decision. We've read the decision of what the president says. But on the proposition you put to me, my lord, when the president engages with whether or not he recognizes the second respondent as a king, he does so with the full knowledge that there is in fact a dispute. However, the courts resolve it. And you would have, in fact, yesterday, and I won't repeat the arguments I made about this matter being on appeal. Justice Matondo's judgment being on appeal on two aspects, which one aspect could torpedo the entire judgment, the recusal aspect. Because your lordship, you correctly say you're not an appeal court, you can't speculate what the appeal court is going to say. If you might have strong views about whether the recusal is well-founded or not, which my learned friend tried to suggest. The point of the matter is whether it was on the issues that are before the Supreme Court of Appeal, the royal family is entitled to engage with those issues. No, well, this is where it's relevant. The president says, I'm relying on the judgment of Matondo. Before the Supreme Court of Appeal, an attack on Justice Matondo's eligibility to sit in that case is mounted. No, it's not. Yes. But the president's... Because there is no aspect of this judgment that stands. Oh, I thought my lord... Oh, sorry. No, I thought my learned friend wanted to say something. But there's no aspect of the Justice Matondo judgment that stands in the Supreme Court of Appeal in the event the Supreme Court of Appeal finds that he should not have sat in the matter. Now, no aspect, whether it's the Mbonisi application or whether it's the other applications. Yes. Thank you, my lord.
So he starts then on paragraph 2, he starts with the application of Queen Sibongile Zulu.
That's correct, my lord.
275-121. That's from paragraph 2 onwards. It deals with the parties in paragraph 4, deals with the factual background in paragraph 8, which deals with the allegations, then it deals with the preliminary issues, paragraph 6, preliminary issues.
Yes.
Then there's the ruling that's on the amendment.
That's correct.
17 and 18. 19 is the third amendment, it goes to 21. Then it says application for my refusal. That is not in that application. And then it says at the paragraph 41. Then it carries on and it deals with that application and the impeachment of will up to the order in 66.
That's correct, my lord.
Then he deals with Prince's releases application. So now if you say that there is an appeal pending before the SCA regarding the refusal, my question is, to take the structure of the judgment, how does that appeal on the refusal issue impact on case 10879 of 2021 feet?
Here is the answer, my lord. If you go to the very beginning of the judgment, where Justice Matondo explains, says 3 applications are brought by various members of the royal family against, that's paragraph 1, against certain members of the same family and other parties. The relief sought is in some instances similar, but it is also different. Since these matters arose from almost the same identical facts and circumstances against the same or slightly different respondents, and interrelated, this court has deemed it appropriate to consolidate case number 2751, 2752, and 10879, respectively, to facilitate their hearing and to avoid conflicting judgments on the same set of facts. The first 2 were consolidated on 25 May 2021 and on 2 December 2021. This court simply adjourned the 3rd application in order that it should be heard together with the other 2 applications. So, no. No, here it deemed appropriate to consolidate matters number. All 3 matters were consolidated. And it tells you the sequence of how they were consolidated. The first 2 were consolidated because the first 2 were lodged earlier. So they were consolidated on the 25th. And the 3rd application was brought in on the 2nd of December. But it makes it quite clear that the 3 matters were heard together. And, my lord, it would be extraordinary if one thinks about it. In the Supreme Court of Appeal, if the judges find that there was a basis for the recusal of Justice Matondo, it is on the basis that the same facts, the facts here that resulted in him consolidating the matters, were essentially the same. In other words, there is no part of Justice Matondo. Remember, my lord. No. But I'm talking as far as the recusal application is concerned. And unfortunately, the recusal application was not really dealt with by Justice Matondo, and the basis of why that recusal, in fact, he says that there was a rumor that he was going to be recused. That application was never really brought to him, and the real questions of why the recusal was brought was not really dealt with. I accept that we applied to the Supreme Court of Appeal on the issue of the recusal, and we were denied that application. That was the problem. but the problem is that, my lord, you are being asked to really split hairs, insofar as you are being asked to split this judgment of Matondo and maintain a certain portion of it as relevant and a certain portion of relevant. The Supreme Court of Appeal will deal with all the issues, and it may well come to the conclusion.
So is the refusal issue still alive as an appeal before the Supreme Court of Appeal?
Yes, it's still alive. The what? My lord, what I would ask your lordship to give us an opportunity is to present this Matondo judgment is the appeal is set down for hearing on the 13th of December. Sorry, November. Thank you. 13th of November. But to just amplify the issue of why it would be a totally oppressive manner of using res judicata on the issue of these applicants here. It's because essentially you close the door on the royal family members to engage with issues that are very central. Yes, and I can forward to your lordship the role.
Res judicata applies where the final verdict has been granted.
That,
It's not final, it's all subject to appeal.
that's correct.
Well, I wouldn't know on certain agenda even what happened, because there might be a reservation.
There would be most likely a reservation, an invitation to make submissions wider than was there. We don't know what the Supreme Court of Appeal will say.
Before we're now debating the matter, if the Supreme Court of Appeal were to review it on 30 November and notion on 14th November dismiss the appeal, then this becomes final.
It would become final, but
Then you'll still say this only becomes final in respect of interdict proceedings and not review.
yes. And of course, the Supreme Court of Appeal dismisses the application. No one really knows what the option that the applicants in that matter may well appeal to the Constitutional Court. I have no doubt that issue will end up in the Constitutional Court. And this is why it's irrational for the president to have done what he did. It's completely irrational, because the president could not have exercised such weighty constitutional powers in the face of pending applications that could, in fact, affect the situation. But in a manner that essentially surrenders the whole identification process to a different... Yes, but my lord, he had been told, he was aware that the royal family, who are the ultimate adjudicators of who should be king, were intended to appeal. And as I submitted, a very short time thereafter, he launched he made his decision, and that decision is the reason why we're here. One must ask the question, what was so urgent for the president to make that decision? In the face of members of the royal family saying, we want to appeal. The president could have waited and given them the opportunity to have all the matters ventilated. And all the various aspects of the identification process ventilated. The last submission, my lord, if your lordship indulges me, is the following. The royal family should not be constricted in what it should consider when they go through an identification process. In other words, they shouldn't be constrained by saying, well, as Justice Madondo says, the will is irrelevant. The royal family, who are the decision makers on the identification process, find it relevant. Justice Madondo can't dictate to the royal family what they should consider in terms of their custom.
It might be here on a more fundamental basis where you and Mr. Tucker diverge views. He says, look, it's just an identification of what has been determined by the customs of the AmaZulu. And you say, oh, this is a consideration when we get closer to, what do you say in your papers? The constitutional monarchy.
Yes, my lord. But yes, but my lord, I'm assisted in my thinking by a number of paragraphs in the judgment. So you will see that just to buttress the argument earlier on that says that what was before Madondo was not, what Justice Madondo was not the review. In paragraph 59, somewhere in the judgment, he says, however, it is common cause that this application is not about who the successor to the throne is, but about an interdict against the implementation of the will of the Isilo and the process leading to it. And then somewhere he says, in the premises, the marital status of the applicant and the validity of Isilo will, that's paragraph 59. In the premises, the marital status of the applicant and the validity of the Isilo's will do not in any way stand in the way of the court determining the issue of succession to the Zulu throne. But it certainly stands in the way of the royal family determining the identification of an heir. Because on two theories, the first one is the great wife theory, right? If the great wife theory is entrenched in the tradition, It's a status, it's a marital status. How can it be justified that there is a claim that the great wife, I beg your pardon, my lord, you look. Sorry? Yes. Yes. No. No. Yes. Yes. No, it was not. Yeah. Yes. Yes. But what are the consequences, my lord? If one looks at the consequences of the application, the consequences are that the king's marriages would be regarded as not marriages, the other marriages. So the order that the applicant queen in the Supreme Court of Appeal wishes to have is an order that recognizes that the civil marriage which she entered with the king. And if that is successful, it has implications for the other marriages that were entered into by the king. In other words, we know what those consequences are. Justice Matondo deals with them. But what is critical is that if the applicant queen in the Supreme Court of Appeal succeeds, well, the theory about a great king by birth falls away, because there would be a problem there with the status of the marriage of the king in that instance. So my lord, the argument I really want to press, and your lordship has to engage with this issue. The royal family before you is asking for a procedural right, an opportunity to engage with the identification process. They're saying that process would require us to have the issue of the wills resolved, the issue of the status of the marriage resolved, because it is relevant for them. Forget the logic of it, because that's the royal family saying these are the issues that are relevant for us. What Justice Matondo believes is relevant or not relevant is not what the royal family believes is relevant. The royal family says we want to know what the status of that will is, and I did make submissions on Monday that in the event that the will of His Majesty of the late King, His Majesty King Zwelithini, was lawfully entered into will, then of course the royal family, as Justice Matondo acknowledges, would not likely deviate from what the late king said about in that will. They would not likely deviate. I understand the matters have somehow gone further than they should have. But the point here, my lord, is that the royal family should never be constrained in determining whether or not in the identification process was there a fraud committed on the king's will. They must engage with that. And if they found that there was fraud, they must engage further with what was that fraud intended to do? What was the purpose of that fraud? Who committed it? Why? And my lord, as they engage with those questions, the fog clears, and they can say, when they believe that something was rotten in the state of Denmark, they can now say, no, it's clear, there's nothing that was rotten in the state of Denmark. Everything is clear. But they must be allowed to engage as far as possible with what they consider essentials of the identification process. And my lord, it's clear from our arguments here that the will of a reigning monarch is irrelevant. The will is relevant. What this judgment of Justice Matondo suggests, sorry? Yes, if the will names a successor, then no, he identified a successor. Yes, and that is where the theory, my learned friend Mr. Smilan will deal with that. But that's where the whole birthright theory falls away, because if the late king, who was the highest expert in the royal law, did not in his will, assuming the will is valid, did not in his will follow that custom by nominating the child who had been identified as a child born for the purpose of being a king, then we must ask ourselves, does that theory really, is it entrenched in our tradition? Because when the king says in his will, I nominate for a successor, I nominate my wife, Queen Mantombi, I mean Zulu, is he not deviating from this right to birth, right to king by birth practice? Yes, so that points the direction to which we should go, because the king can never be suggested that he didn't understand the traditions that governed succession. He understood them very well. And all his sons, all the sons that are eligible for identification, were old enough to be identified or at least to be considered for identification as potential successors. So my lord, the issues, as you would have seen, and my learned friends also acknowledge, the kind of disputes that are raised by this application are such that the res judicata point is just not there's no traction whatsoever. It is being used or activated in an oppressive manner, in a manner that seeks to deprive the royal family of their ancient right, and a right that their grandparents, the great kings of the Zulu nations have followed this pathway. We have to entrench the right of the Zulu royal family to determine and resolve its own affairs. We can't surrender that right to different entities. And the res judicata point would essentially deprive them of that. And we say that, Your Lordship, to the extent you have discretion over that question, you exercise it in favor of upholding the rights that the royal family has, and determine those questions. My Lord, unless there are any questions, those would be my submissions on the issue of res judicata, as the court pleases, my Lord.
Pleases the court, my lord. My lord, my senior, Mr. Masugu, has already started with what I also propose to deal with in my reply briefly, so I won't be long. But before I get to that, on matters of this nature, you and Mr. Parkin yesterday, my lord, had a chuckle about whether or not you can quickly dispose of the issues, and you correctly, and we agree with that, indicated that this is not the type of matter that presents itself to be quickly disposed of, for good reason. And because of that, I would like to begin my address from the beginning of where maybe we should start. So my eyesight is, and I'd like to refer you to the Constitution, the preamble in particular. My lord, the preamble reads thus: we, the people of South Africa, recognize the injustice of the past, honor those who suffered for justice and freedom in our land, respect those who have worked to build and develop our country, and believe that South Africa belongs to all who live in it, united in our diversity. We therefore, through our freely elected representatives, adopt this Constitution as the supreme law of the Republic, so as to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights. Lay the foundations for a democratic and open society in which government is based on the will of the people and every citizen is equally protected by law. Improve the quality of life of all citizens and free the potential of each person, and build a united and democratic South Africa able to take its rightful place as a sovereign state in the family of nations. May God protect our people. Nkosi sikelela, Morena Africa, Morena Buluga, Sitjhaba sa Yesu. God South Africa, God bless South Africa. Mudzimu faluchiseza Africa, Hosi katekisa Africa. I read the preamble purposefully because in a matter like this, it is important that we reflect where we come from. The institution of traditional leadership, prior to the adoption of this constitution, has always been viewed and recognized as irrelevant in society. Irrelevant by the past governments, irrelevant for all intents and purposes, such that those who held positions of traditional leadership were treated as if they were not really truly belonging to this country. And we know the past. We don't have to spend too much time on it. Before you today, my Lord, are the applicants, the members of the Zulu royal family, the leading family of the Zulu nation. Some of you are before you and they are seated behind you. The three main applicants in the Mbonisi application, Prince Mbonisi application, are not necessarily here, but they are also closely observing the proceedings. Now, where am I headed with this? The issue then of succession, as my well, my Lord, yes, indeed so. And well, my Lord, I will get to the definition of the royal family that we submit.
And then if you say, well, we reflect on where we are, where we come from, and the traditional leadership, if I might respond to that at this stage, because that's not a legal argument, the response is, and it is a tragedy that one has to revert to the court to resolve issues in such a manner.
Indeed, it may very well be so, my Lord, that it has come this far. Such is the complexity of the issues for a variety of reasons, including those reasons that occasioned for the past to be what it was and continues in some respects to be today, which is in fact partly, for want of a better expression, the body politic. Yes, indeed, my Lord. Yes, that is what I'm gonna get to, my Lord. It was important that I get to that. Now, they say that the president consulted with the minister and the premier for purposes of recognizing the current king. We dispute that the premier was consulted. That is the premier of KZN. There is nowhere in the papers where it is indicated that the premier was consulted. There is nowhere in the papers. In some respects, we would wish to argue before the courts that even the minister, although she was engaged, that engagement, that nature of the engagement did not necessarily constitute a proper consultation as is required. What happened there, my Lord, is that the president wrote to the minister informing her of the communication he had received, and the minister, as we know, went ahead and appointed a panel, which has been argued is not the investigating committee. Well, she did do that. Yes, she did that. Well, what she did was, yeah, that's not sufficient because she didn't engage with the issues. What the minister did was, upon receiving the reports of the panel, she simply forwarded to the president and passed it on as a fait accompli for President to note and reflect on himself. What actually the President wanted from the Minister by way of consultation, because she's the Minister for Cooperative Government and Traditional Affairs, therefore the assumption is and the presumption is knowledgeable. She's knowledgeable on issues, traditional affairs, which means these are the kind of issues the Minister would be steeped in and would be immediately available to advise the President properly. There's no such engagement that takes place. The report comes from the mediation panel. She simply forwards it to the President, who then, it appears on the information available and the evidence, does pretty much nothing with it. In fact, he ignores it in that respect. Now, we submit that that cannot be consultation, proper consultation with the Minister. I'll deal with what proper consultation is. But, my Lord, if I take you to the... I beg your pardon, my Lord? As a review ground. Well, my Lord, sorry? Yes. Well, the point we are taking, my Lord, is that the reason why the President's decision ought to be set aside is that it's purely on the ground of legality, which is failure to take into account the Minister's views by way of proper consultation. Yeah. In our heads of arguments, my Lord, at paragraph 1, we state as follows. The President, on 16th of March, in consultation with the Minister for Quota, took a decision to recognize Prince Zulu Zwelithini. That decision was gazetted by the President without an application from the royal family, and
Yes, but I read from paragraph 162 of the founding application. You see the President's decision does not comply with the law and the constitutional standard exclusion of performing its function. It is unclear whether the President considered the report of the
Yes.
Investigative Committee of Quota and the letters of the royal family, etc. That was the point made. It wasn't made there to say it was insufficient consultation.
well, I understand, my Lord. I've got the footnote here, 001-38 of the founding affidavit. It's 380. No, it's 380, my Lord. Or you can look at 006-5 of the answering affidavit, where we allege that the President did not consult with the Premier as required. That you understand.
Just clearly in your statement you said there was insufficient consultation with the Minister, but the response does not qualify as proper consultation. And I was just asking, was that the case made out in the founding affidavit? I could not find that.
No, my Lord, I take the point. Yeah, I take the point. With respect to consultation, lack of consultation with the yes, it doesn't show, and there's no contest with it. So on that basis, we submit, my Lord, that the decision of the President to recognize Prince Zulu should be set aside. The next issue that I'd wish to deal with is the issue of the submission by or on behalf of Prince Simagade that the matter be remitted back to the President for the investigating committee to conduct an investigation. The issue of remittance, my Lord, in this case, you dealt again with it yesterday, is not appropriate for a number of reasons. Referring the decision back to the President to appoint an investigating committee would depend on whether or not, firstly, there was a proper identification process, and secondly, whether there was a proper recognition, and whether or not there was no dispute. Because the President's power to start. Yes.
Once there is a dispute, that's the obligation to become the committee appointment section 84.
Correct.
That's the point. And the allegation of whether there's a dispute or not. So, as I understood your argument initially, or the principle needs the application, so that the first step falls away. There wasn't a proper identification process.
Indeed, ma'am. There's no need. Yes. Yes, would submit if the decision does stand for a moment, then there could very well be a remittal back to that investigating committee.
But if the decision, the identification decision stands for the moment, then you say that it's clear, as Mr. Masuku also said, that there is a dispute about that process.
Indeed, madam.
And then, is Mr. Dotson then correct or not? You say that if there is a dispute about that, and once the President knows about the dispute, then he is obliged, not as he has a choice, obliged to appoint a committee as envisaged in sections 84 and 85. And that's the basis for the referral. With the direction.
Well, ordinarily, if there's a dispute, indeed, he is obliged to. He is obliged to have an investigating committee, which we know he didn't do. But we submit that if that were to happen, that we would disagree with strongly, my Lord, because what it does is that, firstly, it recognizes that there is a decision by a royal family, which we dispute is a royal family, and the effect of that is that the applicants who are members of the royal family and say that they are the royal family are then have their rights taken away from them to make the identification decision. Indeed.
There was a decision. The minister wasn't proper in terms of justice.
Yes.
That's the allegation threshold that the doctor said has been reached. Then the President says, well, I appoint the committee because the act says I must. I don't know before I do anything with that. Then the committee doesn't, I don't know how they will work, whether they will different from the mediation committee or otherwise. But presumably they will investigate, and presumably that investigation will take into account those that says it was and those that says it wasn't wrong. And if the committee then says to the President, the allegations of a dispute are valid,
Yes.
irrespective of what Judge Madon said, because he didn't have
All the facts.
those
Yeah.
facts before him, we tell you, President, that the royal family did not properly consider or wasn't properly constituted. Then what does the President then do? He must accept or reject that finding or advice from the committee. But if the committee says to look, it wasn't a proper meeting, and he says, I hear what you say and I agree, I'm not going to recognize, then we're back to the royal family decision, or the royal family is taking a decision.
Well, if that were to be the scenario,
Or almost as if in some other monarchies, there's a re-election.
yes, now I get the point. Well, that could very well be the case. Well, if there's a report that comes back which the president receives, and it says there wasn't a proper royal family meeting, to suggest that he would send it back to the royal family to start afresh is an option. But the applicants take the position, my lord,
That it should be a full review. The decision should be set aside.
this decision should be set aside so that they are able to go back and exercise their constitutional rights as the royal family themselves without involving the president. So what it means is that the suggestion for remittal prematurely brings the president into play and the investigating committee into play in that respect. And that is what would be contrary to the... Yes, that's why they differ, because Prince Smagade takes a broader definition of the royal family, which Prince Mbonisi differs with. So in that respect, my lord, we would not, as the applicants, agree that the matter be remitted to the investigating committee. We submit that the present decision be set aside so that the royal family can exercise its rights and give effect to Section 211 of the Constitution, as it is entitled to do. In light of that, I don't think, my lord, it's, well, maybe I think I'd wish to get into the royal family, the definition of who the royal family is, because I think it is important to be noted. We, yes, and if it's set aside, then the royal family can start however it constitutes itself. And then this court shouldn't, absolutely, this court shouldn't do that, my lord. Yeah, no, forever. No, indeed, it shouldn't do that. Then, my lord, then briefly, there was an issue raised, which Advocate Masuku started dealing with regarding custom. Yesterday, Advocate Pakrin, SC, made a point that a king is born. Well, would submit that that truly is not entirely correct. We have in our heads at length dealt, my lord, with how in the past kings of the AmaZulu nation have been appointed. And they've always been appointed by the elders in the family, who have always been the brothers of the immediate past king, and in some respects were relevant, the sisters. The immediate past, the late king, Zwelithini Kapegu Zulu, was himself appointed by the brothers of the late king Pegu Zulu, and therefore it should follow that since that is the custom, that is what has always been followed from days immemorial. The person to assume the position of the king for the AmaZulu nation should be appointed, should be identified in exactly the same way. The question then would be, who would be those identifying members of the family? And we submit that it is the brothers of the late and sisters of the late King Zwelithini, who are in Lugapusha. And since in any event, and this is undisputed, there is agreement within the broader extended royal family that the person to assume the position of king will come from that house. It therefore follows that only the elders in that house should identify from amongst the eligible sons of the late king the appropriate person to assume the position following the customs and traditions of the AmaZulu people. What that does is it does minimize and take away the argument of one being born to be king. Advocate Masugu indicated how the late king in his will sought to demonstrate that. The late queen herself sought to do the same thing in that in her letter to, well, she was sending it to the royal family, but she was actually sending it to the late Prince Buthelezi. We submit erroneously, otherwise it would have been sent to the correct royal family. What she does there in her letter is that she nominates, and as she says, appoints a son. What that is in recognition of is that it is not solely, and it would not have been solely, her decision. There is somewhere where the engagement takes place, and there is somewhere where a discussion takes place in accordance with submits with the legislation, out of which engagement then a final decision is taken. The reference to minutes that we've heard throughout these proceedings and contained in evidence are simply consultation processes that involve everybody that needs to be involved. That is why in some meetings, some members of the royal family are not there, others are. But we submit, my lord, that when it gets to the final decision-making stage, not everybody that's been part of consultations will be involved. There's going to be a much smaller group. We define also in our papers Amakhanda and the role of Amakhanda in respect of the other royal houses. The only point I wish to make there, my lord, is that in respect of succession within each of those houses, it's not disputed and it's common cause that that issue of succession there is dealt with only and solely within that house. They may also have consultations with others, but when it comes to deciding who is going to be Ikhanda of a particular royal house, only the relevant members of that house take that decision. We therefore submit that there should be no reason why this family should be treated differently from that practice. It is entitled to make a decision on its own after concluding all the necessary consultation processes. We submit that that is the custom, that is how it has always been, and there's no suggestions at this stage that that should change. Therefore, the 14 May meeting was not the meeting of the type that is envisaged in Section 8A for purposes of identifying a person to assume the position of king. That was not that type of meeting. That was a consultation meeting, just like all the other meetings that took place. All that happened is that the meeting of the family to take a final decision had not yet taken place because it was overtaken by all the other events. On that basis, we submit, my lord, that the custom must remain the way it is, and in setting aside the decision of the president because the proper processes were not followed, this court will be giving effect to Zulu custom and tradition and the constitution accordingly. My lord, the last point that was made was that there was no dispute. As the court pleases, ma'am. Okay, so he kicked out. He kicked out. What's his name?
intervention in terms of Section 84. And we have reflected in response, and we have, as a result of that reflection, amended the draft order, and that is the one that's put up, to which I've given you the reference.
All right. And in effect, that only removed paragraphs 1 and 3.1 of the initially proposed draft.
It doesn't remove paragraph 1, it amends paragraph 1.
All right. Let me just see.
It's declared that the purported identification of the second respondent as a seal or kin of the Zulu nation, the persons attending a meeting on 14 May 2021 convened by the 8th respondent reporting to the AmaZulu royal family. Identification decision gave rise to evidence and allegations as contemplated in Section 84 of the Traditional and Khoisan Leadership Act, number 3 of 2019, that the identification of the second respondent was not done in terms of custody or custody. And then we have removed what was 3.1 from 3, which was the review.
Sorry, let me just, so the declaration does not reflect on the meeting itself. It just declares that it gave rise to allegations as contemplated.
Indeed.
I see. So that gave rise to evidence. That evidence includes then what Mr. Simelane now referred, Princess Thembi Ndlovu's letter, and the documents.
The letter of the 28th.
And the third.
The letter of the 3rd, and every other manifestation of the contestation that is followed from that. And we will submit that is plainly established. Would the other change that I need to draw to your attention?
The previous 3.1 was then removed.
Was removed.
Yes.
Completely, and there's no replacement. Then, my Lord, we've made a small change to 4. So it says, matters remission to the first respondent is directed to act in terms of Section 84 and 5 of the British Code in respect of the evidence and allegations that the identification of the second respondent was not done in terms of customary law customs. And then I think this is the new point, and to appoint an investigative committee to conduct an investigation afresh and provide a report in accordance with the following procedure. And the rest of the order remains then the same. And I will make submissions in support of the word afresh.
You mean that is to distinguish it from the mediation report already produced, or why is the word afresh then used? If he appoints a committee, that's the first time that the committee would have been appointed.
Well, it would deal with it afresh in the sense that, frankly, we will submit that they can't be bound by the judgment of His Lordship. And that would be the main point of it. But your Lordship is also correct, they wouldn't be bound by what the findings of the mediation say, and it would allow them to make a fresh start.
I would have thought that if a committee is appointed, that would imply that they should conduct their inquiry from that day onwards, which would imply afresh. If you now want to impute in afresh other directives to them, such as consideration of Judge Madondo, wouldn't that be improper?
We heard submissions yesterday about the fact that that investigative committee would be bound by the judgment of His Lordship Justice Madondo. Well, that would completely remove any successful review and eliminate our client's right to it if they were to traverse the same ground. And I'm concerned that if one doesn't put in a statement like that, which is reasoned with respect to the Lordship's judgment, it does leave the potential for that argument being raised again. And that would be a catastrophe. That would be essentially our days in these 3 days in court have essentially been in vain.
All right. While we're on that topic of afresh and the judgment of AJP Madondo, and I assume you'll get to it in the res judicata. If you'll get to it, then just tell me you'll get to it. But what is the impact of the date of the 15th of November in the SEA mentioned by Mr. Masuku, Mr. Simelane? They said, or Mr. Masuku said, look, if the 13th of November comes, and if pursuant to that, the same day, the next day, or on date of a reserved judgment, the appeal is refused, meaning that the judgment is not overturned, then they would still argue it is not res judicata binding on this court as it was made purely in the context of an application for an interim interdict, irrespective of the finality or apparent finality of the findings.
We, from the point of view of Prince Makadi's case, we were already at that point. We're comfortable with the matter to be decided by your lordship on the basis that the appeal was refused. And we're comfortable with your lordship deciding on the basis that there was never an appeal. We're confident that we can persuade your lordship that if there was no appeal at all, your lordship is not bound on the basis of res judicata.
Notionally, though, as a possibility, and I put it no stronger than that, if the SCA were to overturn the whole of the judgment on all three applications and the orders made by Madondo AJP, then the res judicata defense falls away. Or, no, well, the appeal is upheld, it's overturned, yes, then there's no finality on that.
It goes away, but the difficulty is that all you did at the end of the day was dismiss the application.
Yes.
But the other difficulty we have from Prince Makadi's camp, as it were, is that we respect the fact that Madondo, AJP, kept the three judgments distinct, and he was supported in that. He was supported in that by Prince Zulu's legal team. They were insistent on that, particularly in relation to the Prince of Polisi application. There was not a, and greatest respect to my friend, there was not a consolidation of the Prince of Polisi application. It was only heard together. And from the argument of my learned friends, the res judicata issue is based on that third judgment. That is where he got the between his teeth and supported to decide these issues. So, with respect, we don't see the appeal impacting at all on the Prince of Polisi application, because really, with your lordship, as I understood the exchange with my learned friend, that it relates to these other two cases about the marriage and the will. And Madondo expressly found that those had nothing to do with the judicial leadership dispute. So from a res judicata point of view, those two judgments cannot have any impact. The only potential res judicata comes from the Prince of Polisi application. Just briefly.
And where he dealt with the will issue, the direction to institute action was limited to the authenticity of the will, the referral to trial, as it were. Insofar as he dealt with the will issue, when he made an order in that issue, he didn't make an order encompassing all three applications. It's separate orders, and that he only referred the will issue to be prosecuted by way of action. I see. All right.
And the lordship is reminded, not just the judgment, but the orders were all carefully kept as distinct. Just to, firstly, before I get into res judicata properly, reiterate the point that there was a suggestion from my learned friend Mr. Packman that Prince Makadi ought to have appealed against the police judgment. But Lord, it's trite that you appeal against the order. You don't appeal against it. You don't appeal against the judgment. And the suggestion is that by ruling against the order, we could have attacked the paragraphs in the reasoning in the judgment, but an appeal doesn't achieve that. And an appeal would have failed. The order at the end of the judgment is correct. It was an interim interdict application brought on the basis of a rumour.
On the date of coronation. But the decision was, but you don't have any right to ask for a stay because of the findings that he made. So one could have said, I want to appeal your finding that I don't have any right.
But no, one could only appeal the dismissal, and all that the Supreme Court of Appeal will do, it will get to that point in his judgment where he says expressly, coronation is coming, the coronation date is coming to an end. This entire application is irrelevant. That's his word, irrelevant. That's where the appeal would be to the end. So there's no chance of revisiting those findings. And Lord, the assumption is made that Prince Makade has limitless funds to litigate. He doesn't. And I'll come to the significance of that in the race judicata. Lord, there was observation made by my own friend Mr. Fakra that we somehow had not kept in touch with the developments in relation to race judicata, and we're trying to advance a version of race judicata which predates the judgments that suggest that more flexible approaches are adopted, and sometimes it's described, we would say wrongly, as issue Estoppel. But in fact, if one looks at our supplementary heads of argument, that isn't correct. If one looks at paragraph 35, we recognize those judgments and we in fact apply them. But the important point, my Lord, is that there is a concession involved on the part of Mr. Fakra, and that is that they are reliant on the more relaxed or flexible form of res judicata. When one does that, the judgments say that there are important proportions that kick in. And Lord, those are dealt with in our supplementary heads of argument at 062 20, paragraphs 35 and following. If I can just take the call. Say that the courts have recognized that in certain circumstances those requirements may be relaxed. However, they emphasize that in doing so, the following will obtain. Any such relaxation will require careful scrutiny. Each case will depend on its own facts, and any extension of the defense will be on a case-by-case basis, and with great circumspection. Unless carefully circumscribed, the defense of res judicata is capable of producing great hardship and even positive injustice to individuals. In relation to the same person requirement, it will be necessary to consider whether the person sought to be bound by the earlier judgment had a fair opportunity to participate in the initial litigation where the relevant issue was litigated and decided. In relation to the same cause of action requirement, a relaxed application would still require that the question decided in the earlier case is substantively determinative of the outcome of the case where the plea is raised. And then we deal with the Royal Sichamber judgment. We then go to paragraph 36 to say, to these we would submit should be added the following. The raising of the plea within its strict or relaxed form must not give rise to the deprivation of a fundamental right of the party against whom it is raised. If that is the outcome, the court would have acted in breach of Section 8 of the Constitution, insofar as it provides that the judiciary is bound by the Bill of Rights. We make the following preliminary submission on this point. This is the only application that Prince Makade has brought to court. His approach to litigation has been conservative, as it should be. His remedy is a review. He did not jump the gun. He waited for the administrative action to be completed through the President's recognition process. He asked for reasons from the President, as he was entitled to do in terms of Section 5.1 of the Promotion of Administrative Justice Act. The President was obliged to respond in 20 days. He didn't do so in breach of Prince Makade's rights. This case is Prince Makani's one and only day in court. To deprive him of it on the basis of a flawed interlocutory application linked to a dispute over the signing of a will based on a rumour conducted in a different judicial court in which he justifiably did not participate, and which came to court long before his review was granted, would do him a profound injustice. In one blow, it would strip him of at least two fundamental rights in the Bill of Rights. His right to judicial review of administrative action impacting him in section 33(3), and his right of access to court in section 34. It would offend the rule of law and the principle of legality enshrined as a constitutional value in section 1. With respect, this is something this court cannot countenance. Well, if I may, while we're there, just quickly do a correction on those heads. I made a bit of a hash of the Caesar stone and cook, which comes in the next paragraph. I can just ask you all to bear in mind, page 062, it should read in the fourth line, the Caesar stone of plea of this independence was successfully raised by Caesar stone as defendant in proceedings in South Africa, where it had sued in the same contract as plaintiff in Israel. Likewise, in Cook, Miller as defendant successfully raised. The words need to come out in the then Supreme Court. Successfully raised the plea of this independent and sued by Cook on certain promising notes in the magistrate's court. On the basis that he was plaintiff sued Cook for breach of the contract and denying the issue of promising notes in the WLD. My apologies, because that takes some thinking about that case, and I've only added to the conclusion. If we can then move on.
Yes, because the plea must have been raised in the first instance. That would have been in the Magistrates' Court, not the Supreme Court.
Indeed, and it's complicated by the fact that it ended up on appeal from the Magistrates' Court in the High Court. But so apologies. But the bottom line was the defendant gets sued on the promissory notes as defendant. Meantime, as plaintiff, he's busy raising a claim on the basis of a breach of the underlying contract. And we have obviously no difficulty with that particular. If I can draw to the court's attention a judgment which was referred to, oddly not referred to in Burma in the SCA, but was referred to in the majority judgment of Campbell J. in Burma. And he refers and substantially bases his judgment on the Constitutional Court's decision in S versus Malawi. We uploaded that onto case lines. So it's not S versus Malawi, it's Malawi versus S, other way around. It's at 071-563. Lord, that case, it's a criminal case. What happens is three co-accused are convicted. Malawi ultimately brings an application to the Constitutional Court for leave to appeal, and it is refused on the basis that it's fact-based. Two of his co-accused or co-convicted then bring an application to the Constitutional Court, and they throw in, together with the factual challenges, some constitutional points. They are then successful. Consequence is, Malawi is still sitting in jail. His co-accused have been let out. So he brings a second application to the Constitutional Court, and again applies for leave to appeal. And the Constitutional Court, this time he does raise the Constitutional Court and says also, look how you treated my co-accused. And the Constitutional Court there held that yes, it was a situation of res judicata, but it was one that had to be, because the circumstances had to be relaxed. And I'd just like to read from paragraph 37. It's at 071-572. Justice Turon says the following: the incremental and conservative ways that exceptions have been developed to the res judicata doctrine speak to the dangers of eroding it. The rule of law and legal certainty will be compromised if the finality of a court order is in doubt and can be reduced to any substantive way. administration of justice would be adversely affected. The parties are free to continuously approach courts on multiple occasions in the same matter. However, legitimacy and confidence in the legal system demands that an effective remedy be provided in situations where the interests of justice cry out for one. There can be no legitimacy in a legal system where final judgments, which would result in substantial hardship or injustice, are allowed to stand merely for the sake of rigidly adhering to the principle of res judicata. Where significant or manifest injustice would result, should the order be allowed to stand, the doctrine ought to be relaxed in terms of section 173 and 39.2 of the Constitution, in a manner that permits this court to go beyond the strictures of Rule 29 to reveal its part of the decision. This requires rare and exceptional circumstances where there is no alternative effective remedy. This accords with international approaches to res judicata. The present case demonstrates exceptional circumstances that cry out for flexibility on the part of this court in fashioning a remedy to protect the rights of the applicant in the position of Mr. Willanzi. And the important, I would submit, principles that come out of that is the flexibility of approach doesn't only work one way, so as to make it easier to deprive a party of a remedy. It works the other way too. Flexibility means don't apply these to cause an injustice, so as to cause an injustice. And importantly, the court motivates the approach on the basis of the interests of justice, applying the court's powers that this court enjoys in the order of the Supreme Court's enjoying section 173 of the Constitution. And it's that principle, section 173 of the Constitution and the interests of justice, that must ultimately determine how Justice McDonald's judgment is to be viewed in this particular case. The judgment also quotes in paragraph 38, Canadian Supreme Court judgment of Danila versus Ainsworth Technologies, and there the court said the following. Consider whether application of issue estoppel in the particular case would work an injustice. Rosenberg J.A. concluded that the appellant had received neither notice of the respondent's allegation nor an opportunity to respond. He was thus confronted with the problem identified by Jackson J.A. dissenting in Iron versus Saskatchewan. And then he quotes that case. The doctrine of res judicata being a means of doing justice between the parties in the context of the adversarial system carries within its tenets the seeds of injustice, particularly in relation to issues of allowing parties to be heard. On considering the cumulative effect of their foregoing factors, it is my view that the court in its discretion should refuse to apply issue estoppel in this case. And we would submit that if this court stands back and views the entirety of the circumstances, a grave injustice would be done against Prince Makadi if he were to be deprived of those two fundamental constitutional rights, the right to have disputes determined fairly in a court or similar tribunal in Section 34, and the right of judicial review constitutionally entrenched in Section 33.3. Interesting, Lord, we made these arguments about not stripping Prince Makadi of his fundamental rights in the supplementary heads of argument. We heard not a murmur of argument in response to these. But, Lord, against that backdrop, if we can go through the discipline of looking at the three requirements of res judicata. So the first is the issue of the same parties. Lord, cases like Caesarstone and Cook evidence a very cautious softening of this component of the rule by allowing earlier proceedings where the defendant was the plaintiff to provide a basis for the cognate plea of lis pendens. So if one reads the Caesarstone judgment, one sees His Lordship, Mr. Justice Wallace, being very careful about departing from the original rule. It has to be the same plaintiff and defendant each time. This time he allows that switch to take place so that the person who was sued as defendant in Cape Town could raise the case that he had brought in Israel as plaintiff. But the court is terribly careful about doing it. It goes back to Cook, carefully evaluates Cook where the same thing was done, to see if it was right. Lord, here we don't have that. Prince Makadi has never brought an application against any of the respondents. Prince Misuzulu has never brought proceedings against Prince Makadi. In all the applications before Madondo AJP, both
Prince Simakade and Prince Misizulu were respondents. This is not a rerun of litigation between the same parties, even on the more flexible approach to the requirement. Would we also draw attention to what we said at paragraphs 40 and 41 of the supplementary heads, that's at 06223.
That's what on the relief that you now proposed in the amended draft order, where the identification decision is at the moment left intact pending the committee's investigation. Does one then have to go the whole route of raising the data? Because the only issue already found which impacts on the section 8.4 relief made by Magondo AJ was that there was no appropriate dispute, or that the allegations of Princess Tembi was not sufficient enough to trigger that investigation. It's only that finding which can constitute the Judicata effects.
It's only that finding, indeed, Lord, it's only that finding that can prevent us from getting the relief. But if the balance is left intact, then all that's going to happen is that the moment we try and exercise the remedy that we get on review in these proceedings, and bear in mind, Lord, it has to be what the Constitutional Court has said over and over again, it has to be an effective remedy. And
I need not, again, as other practitioners, sit as a court of appeal what Magondo J did or not do, or found or not found, even taking into account your argument that you went beyond what the proceedings required you to do at that stage. I need not make a final, because the Judicata will just find the score. It might not necessarily not necessarily bind a committee, or it might, if practical argument is correct, but they're also still be bound by that. But you got, if the relief you seek is granted based on the fact that the complaint issue is not less Judicata, and allowing the matter to be further developed and investigated, then I can't make a finding, or need not make a finding. It may be improper to make a finding. The rest of the judgment is not finding for Judicata on this court, thereby opening the door to the committee. It's different how the committee might investigate or the court might do.
Lord, we would submit that that would be most unfortunate, because we're entitled.
It's not declarative then to say, well, that's on the door, the HFP is not binding on whatever committee the president appoints.
I don't think it's necessary to go so far as seeking a declarative, Lord. But well, if it amounts to it, then it's got to be done with respect, because Prince Simakade is entitled to an effective remedy. One has already heard Mr. Puckrin saying loud and clear in these proceedings that that committee sits somewhere down in the food chain, well below the courts. So that argument is coming like a train on a track in that investigative committee. And that's going to spike it as far as Prince Simakade is concerned. He will not have an effective remedy in those circumstances. And we would submit that if this court simply says in its judgment that it is not bound, and perhaps your lordship will allow me to take the argument further to see if I can provide your lordship with additional comfort about saying that. And in any event, my lord, it seems to me that they're all tied together. One can't, if your lordship isn't bound by the Section 8.4 finding, why should your lordship be bound by anything else that was in the judgment? So we would submit that that's necessary that would indeed be necessary to protect, and that's specifically why. Sorry, I'm not with you.
This will also take you now beyond the supplementary heads to the same party argument. Will take us closer to the same course of action argument.
Yes, Lord. And I think we have helpful submissions to make in relation to the same cause of action.
Would you
And that is in the court will just allow me to get my bearings. I wanted to say something about 40 and 41. So just briefly, my Lord, 40 and 41, while we're on the same persons issue, it is undisputed that whilst joined indirectly through the royal family, Prince Simakadi's interests were not represented in the litigation, and he did not participate in any way in the proceedings on the basis of which res judicata is proceeded, i.e. case number 10879, pending the decision of the court on the other two consolidated applications. The application sought no relief against Prince Simakade whatsoever. There was therefore no reason for him to join as respondent, nor was there any reason for him to intervene as applicant. And I've already pointed out that the application was patently flawed. As Madondo AJP found, Prince Mbonisi was acting on his own frolic. Nowhere in the founding affidavit of Prince Mbonisi was anything whatsoever said about Prince Simakade or any of the issues in dispute in those proceedings. It was the barest and most inadequate of pleadings. And then in paragraph 41, we make the point that by no stretch of the imagination can one say that Prince Simakade is one of the dramatis personae in those proceedings. And, Lord, this point here is important because our learned friends say in their heads of argument that heads of argument were filed on behalf of Prince Simakade. That is not true. No heads were filed on his behalf. This is unless one treats the second respondent and Prince Simakade's heads of argument as being those of Prince Simakade on the basis of his membership of the royal family, because that's what they purported to do. If that is so, then a serious and unethical injustice was done to Prince Simakade by the second respondent and Prince Buthelezzi's legal team. This is because those heads of argument, particularly insofar as they concerned the marriage and will applications, were pointedly adverse to Prince Simakade and in favor of the second respondent. The legal team would have been conflicted. It would be most surprising if three respected members of the bar, one of them senior counsel, would engage in such conduct. If they did, which we submit could not have been the case, the second respondent's argument for the application of res judicata is all the more unfair and unjust. So, Lord, that on the same parties issue, I understand the privy's argument that says that Mbonisi and Prince Simakade are one and the same person. I understand that that hasn't been persisted. It's in the heads of the second respondent. I understand that's not being persisted in. Then, Lord, to come to the issue of the same cause of action. Lord, on the same... Indeed, my Lord. What I'd like to do, though, my Lord, is to I think it will be of assistance if I can first make some submissions in relation to the Brimmer judgment that was relied upon by my learned friends, and then I'd like to take your Lordship to the founding affidavit, in that application, in the Prince Mbonisi application, because it's very revealing as to what was in fact before Judge Madondo. But before going there, if I may just read from paragraph 20 of the SCA's judgment in Brimmer. They say, these passages illustrate that the focus is not, therefore, upon what orders the respondent sought before Traverso DJP. The form of the application and the nature of the relief sought, i.e. that it was interim, is not relevant. The question is always, what issue of fact or law was decided by the court in the proceedings, and was it finally decided? In order to answer the question, reference must be made to the founding affidavit that served before Traverso DJP. It is against that background that the judgment must be read. Lord, that supports the point we make in the head that you go to find out what has and has not become res judicata. One has to have regard to the pleadings. Lord, that we've put the Brimmer SCA judgment on case lines. It's at 071537. And Lord, he makes the comment about it being irrelevant whether they're interim relief. We say that that comment must be read in the context both in which it appears in the judgment in paragraph 20 and in the context of the cause of action component of those three aspects of res judicata. Because he goes on immediately to say the question is whether it was whether it was a final order. Well, usually in interim interdict proceedings, it's not going to be intended that it's final. So really, that issue is neither here nor there. But the important point is look at the founding affidavit, and if we do that in this particular case, that is to be found at case line 056242 in the Simakadi bundle. 056242-242. So that, my lord, is the founding affidavit, and the preliminary observation we would make on that page is that your lordship will not see Prince Simakade's name there anywhere, but he is there in the 8th respondent. It says, members of the Zulu royal family as listed in Annexure A to the notice of motion. And if one goes back and looks at the notice of motion, yes, indeed, he is one of a very large number of people who are listed as being part of the royal family. But with respect, hardly a dramatis personae. Lord, if we then move through the founding affidavit, and I'd like to do so in some detail, we move to page 056-243. He introduces himself, makes the usual submissions. He says, I'm the applicant in this application. I bring this application in both my own name, and this application is supported by some members of the Zulu royal family. Well, your lordship is welcome to prevent me from doing that. But the point I'm trying to make, my lord, is that if one goes through it, then there is nothing to suggest that there was any form of duplication with what has taken place in front of your lordship in these proceedings. There is no reference to Prince Simakade whatsoever, either in the founding affidavit or in the affidavit of Prince Buthelezi. There is no reference to, for example, the meeting of the 14th of May. In the founding affidavit, which is the starting point, and determines the ambit of the dispute. Lord, if I can just pause, for example, at page 056246. A point was made in relation to 8.3. Yes, that aspect wasn't interim. Well, it seems whether it was interim or not has been lessened in its significance by the Brimmer judgment. But, my lord, if you look at it, it says, in the event that the fourth respondent has completed all process envisaged in section 17 of the KwaZulu-Natal Traditional Leadership and Governance Act, the third respondent is interdicted and restrained from issuing the circular of recognition to the first respondent as Isilo AmaZulu. Now, that is in fact a meaningless form of relief, because there are no averments in the founding affidavit to say that the condition is fulfilled. The fourth respondent is the Premier. All the Premier does in terms of the provincial legislation is really act as a messenger and is the person to organize the party at the ceremony. There aren't any processes that he conducts. And it's not taken, that relief is not taken up in any way whatsoever in the founding affidavit. There isn't even an averment that, in fact, those processes were completed. And there can't be, because there aren't any in the statute for him to do. And if your lordship looks at pages, and I won't take your lordship through them, but 056246, 257, and then 248, all over the place, you simply see references to the rumors of this coronation that's going to take place, and they want to stop a coronation from taking place. How does that possibly relate to the proceedings before your lordship in any meaningful way? It's devoid of anything to do with the current dispute before your lordship. And everywhere it simply says we want to protect the provision, protect the position for a couple of days while those other two cases are heard. There is no call on the court to resolve the traditional leadership dispute at all. And my Lord, the place where one would expect the dispute that plays out in these proceedings to be played out in the founding affidavit is where they refer to the prima facie right. That's towards the end of the affidavit at 056259. Because that's what happens in interim interdict proceedings. That's where you get into the debate about the case. What does he say? He says, I have a right and interest in the affairs of the royal family, in particular the outcome of the pending consolidated applications. I have a right to access to court and to have any dispute resolved through the application of law in a fair public hearing. I assert that as a member of the royal family, I have a right to insist that there be compliance with the law and the Zulu customs. Accordingly, I submit I've made out a case showing the nature of the right I want to protect. That isn't a debate about the issues that are before this court. Under the balance of convenience, the closest, that the high water mark is under balance of convenience. There's a paragraph that says the identification and nomination of the first respondent as the successor to the late His Majesty King Goodwill Zwelithini is subject of the court challenge. If the process is found to be unlawful and invalid, the royal family will be required to properly constitute, to nominate and appoint the successor in accordance with the customary law and applicable laws. I submit that the balance of convenience favours the granting of interim relief. That provides no platform whatsoever to decide the issues that are before your lordship today. So, my Lord, that's what the SCA tells us to look at. We look at it. There is nothing there to support res judicata. If we look at the other two, the will and the marriage. How can Madondo says the will and the marriage have nothing to do with this case? So those can't be used as a platform to inject that issue into the proceedings. And I'll demonstrate, your lordship, that Prince Misuzulu was also against any such attempt. And Lord, Prince Buthelezzi's affidavit is equally irrelevant. His grounds of opposition are summarized at paragraph 10 on page 056265 in his affidavit. 10.1, applicant has no locus standi to bring these proceedings. 2, there is a material non-joinder of necessary parties. 3, the matter is alibi lis pendens and is yet to be determined by this court in fewer than 5 days from the time this urgent matter has been set down. That's referring back to the two main applications. 4thly, the matter is not urgent. Indeed, my Lord. Doesn't make sense. And finally, the application is misguided and the applicant has no right, prima facie or otherwise, to the relief that he seeks. The official coronation, as envisaged, is not imminent. That is what that case is about, my Lord. Lord, if I can then refer your lordship to paragraphs 51 to 58 of the supplement. He deals with the royal family.
The question is, if the applicant did not bring the decision or a review thereof into the dispute, was it not brought in by way of the affidavit of the late Prime Minister?
With respect, no. There's this brief reference to the role of the royal family and how it is constituted, but it really goes no further than that. and it's related to an issue of standing, as I understand it. It's not, and the heading for that comes at page 5, locus standi and material non-joinder and alibi lis pendens. So he's saying you should have joined more people, and he's saying there's a lis pendens, and he's saying you don't have standing. He's saying the royal family consists of this, you should have joined all of the people in the royal family, and you haven't done so. That isn't the dispute before this court, my lord. And one has to take into account the purpose for which it is raised. But if one's also testing this against what does Prince Simakade notionally do if he was ever served with this, and we don't know whether he was ever served with this, he looks at the founding affidavit and the notice of motion to see what this is about. And Lord, I would have run a mile from this case if I was in Prince Simakade's position. Wouldn't have gone anywhere near it. If I remember correctly, the notice of motion also has a provision that says if he opposes, costs will be sought against him. So it's entirely appropriate that he has nothing to do with this case.
And you say then, in considering the res judicata issue, the court should do the same as in Bruno's case.
As in?
Bruno's case.
Indeed, my lord. Indeed. And we say that, yes, there are statements that my learned friend has referred to that might lend them some support. Look at the overall picture of what happened there. Overall picture of what happened there is similar to here. Lost the interim relief, but res judicata still failed. With respect, one has to be terribly careful about interim proceedings, for whatever reason, effectively chaining parties, particularly in a party that had nothing to do with the proceedings, in terms of later res judicata. And Lord, just while we're there, sorry, I was about to go to paragraphs 51 to 58. If I can perhaps just take the court there. Lord, what does appear to have happened, this is at 062-31, what does appear to have happened in arguing this application is that counsel for Prince Mbonisi, without any foundation whatsoever, therefore, in the founding and answering papers, ventured into some of the issues that are raised in the present application. In response to this, the second respondent and Prince Buthelezi quite correctly said as follows. This is from their heads of argument. It is accordingly unavailing for Prince Mbonisi to rehash the arguments advanced by the princesses in their application regarding the propriety of the identification decision and piggyback on the evidence in those applications in the absence of a consolidation. Because they also made the point there was no consolidation, and if anyone's to be believed, it should be them. They were there. Let alone to embellish the princess's application by asserting grounds which are not pleaded even by them. From this, it is clear that the assessment of second respondent and Prince Buthelesi's counsel, quite correctly and in contradiction with their opportunistic stance in raising res judicata in these proceedings, was that nothing on the pleadings in case number 10879/21P justified a consideration of the identification decision in favor of the second respondent, let alone anything that followed that. On that analysis, and without even going to the judgment of Madondo AJP, it is common cause that the present review application of Prince Simakade and the abortive interim interdict application of Prince Mbonisi are not based on the same cause of action. On that basis, too, the plea of res judicata must fail. Against that explanation of the pleaded case before him, once Madondo AJP pointed out in the second paragraph of his analysis that there was no coronation underway and the application had become moot and irrelevant, it was incumbent upon him to dismiss it. Instead, he impermissibly took upon himself, purportedly on the basis of the interests of justice and the Zulu nation, to deal with the question of the successor to the throne. Now, my Lord, the Supreme Court of Appeal has recently had cause to comment adversely on such judicial conduct. Indeed, my Lord, and we quote the judgment in which your Lordship will be aware of, Road Accident Fund versus MKM on behalf of KM and another. We also draw your Lordship's attention. Indeed, my Lord. And then there is also the Taylor judgment, also from the same source, my Lord. 2023-5, SA 147 SCA, 8th of May decision. And there's also the Advertising Standards Authority, I think is the other judgment from the same source, my Lord. But my Lord, we submit that is precisely what was going on here. Justice Madondo, with the greatest of respect to him, and he's written a very handy and thoughtful book on customary law. I have it with me. He is certainly an expert in the area. But we submit that in fact, that was, with the greatest of respect, the difficulty. It was an issue in which he was interested, and that is what pulled, with the greatest of respect, pulled him off track, as it were. And Lord, we submit that in the light of those three judgments, were this court to hold itself bound by the Madondo judgment, we submit that it would be in conflict with those three judgments, frankly. And if one looks at the scenario that might follow, if your Lordship were to decide that you were bound, the implication of that would be then that the Supreme Court of Appeal would be bound if this judgment went on appeal. If it went further to the Constitutional Court, they would also be bound. So you would have all the levels of the courts bound by what was, with the greatest of respect to judicial frolic in KwaZulu-Natal. With respect to the appellate courts are never going to countenance that. And it's preferable that that problem be dealt with at the High Court stage now, with respect by your Lordship, to ensure that the injustice that would potentially be inflicted by a res judicata defense is stopped dead in its tracks. Lord, the Constitutional Court in NDPP versus Zuma also had something to say about it. That's at paragraph 57 on page 06233. It says, judges as members of civil society are entitled to hold views about issues of the day, and they may express their views provided they do not compromise their judicial office. But they are not entitled to inject their personal views into judgments or express their political preferences. Not the political part, Lord, but there's a personal interest at stake here, and we submit that in personal interest in the sense of not an interest in the sense of I'm interested in something. I'm academically or jurisprudentially interested in something. And certainly not, we certainly don't suggest that it was Indeed, Lord, and there's a very important component of it that both of my junior counsel drew to my attention, and that is that you have the right to the record in a Rule 53 application. Prince Makade, at the time of the interim interdict application, would have had access to very little information. What makes it so different in a review is you get the record. It's incredibly important. And what we did on behalf of Prince Makade is that we requested the record in respect of the identification decision, the recognition decision, and the coronation decision. All of those. And that's why your Lordship is able to have a debate on the basis of what appears to be a completely different evidence base to that which was before his... Indeed, Lord. Lord, if your Lordship will give me a moment to catch up with where I was in my notes. Just another relevant aspect in relation to the same relief is what the full bench decision in Brimmer had to say. Because the full bench in Brimmer...
Irrespective of how we may argue the older AJP how far he went when he decided it was not open for him to decide at that stage that the decision, the identification decision, was unlawful, against Zulu custom, and could or should be set aside. He could not make that decision.
Indeed, indeed.
I understand that that's a fundamental difference between what is framed in the review application of that decision and an interdict stating I want to assert a certain right training something.
Indeed, but he also couldn't decide the dispute and choose between Prince Makade and Prince Misuzulu. In no way, shape, or form was that on the papers before him. Indeed. Lord, if I can just briefly refer to, and I won't read the whole quote, refer your lordship to the full bench decision, because it's helpful in that it does follow Mulaudzi in the Constitutional Court, unlike the Supreme Court of Appeal, and it's helpful because of the similarity with this case. And if I can just ask your lordship to make a note of paragraphs in that regard 74. Sorry, the judgment is loaded on case lines at 071543, and the parts that are relevant, my lord, are paragraph 74 at 071-557, and it sets out and Lord, if I may, I apologize for detaining your lordship, but if I can just read, because it relates to an important issue that's come up in the answering argument, Lord. Just quickly, the Constitutional Court has adopted a similar approach to, this is now Mr. Justice Gamble speaking, the Constitutional Court has adopted a similar approach to issue estoppel. In that court's second judgment in Malawi, Taron A.J. conducted a detailed examination, and she commenced by explaining the foundation. And I won't read that. We read from 16 of the judgment. Then, after reviewing the aforesaid international common law countries, the learned acting justice concluded, and this is paragraph 30 of Malawi, the general thrust is that res judicata is usually recognized in one way or another as necessary for legal certainty and the proper administration of justice. However, many jurisdictions recognize that this cannot be absolute. This is because to perpetuate an error is no virtue, but to correct it is a compulsion of judicial conscience. So, Lord, the argument before you that whether it's right or wrong doesn't matter is not the law anymore with respect, Lord. The law is as per Malawi at paragraph 30. Gamble then goes on to say, it is trite that the party seeking to rely on the defense of res judicata must allege and prove all the elements underlying the defense. In the result, I'm persuaded that Brimmer was not afforded the opportunity before Traverso DJP to litigate this cause of action in relation to damages to finality, and that it would thus be unjust and inequitable to uphold the special plea of issue estoppel. My Lord, it cannot be said that Prince Makade was afforded the opportunity of litigating his cause of action to finality before Madondo AJP, when his name does not even feature in the pleaded case. We submit that the irrelevancy of the wrongness argument could never apply to a judgment that was patently obiter. This was not an issue that has been properly pleaded, has become moot, and is then decided in the interests of justice. It is an issue that has not been pleaded at all. It was not permissible to decide an unpleaded issue that was entirely unnecessary for the grant of the dismissal order handed down. And once one starts to look at it, the judgment is permeated with errors, as we submit our argument has been shown, particularly once one gets the evidence that came out through the record. That particularly is so in relation to the letter of the 28th of May. Justice Madondo finds that they don't make the necessary allegation to cover Section 8.4. They make that allegation in the heading and in the introduction of the document. The whole 88 pages, the ratio of it is a non-compliant identification under customary law. And then, my Lord, the last point I was going to make, in fact, I've already submitted initially up front, and that is we would submit that it would be most unfair if a review was granted in respect to the President's decision, but it was left in a situation where that judgment could come back to haunt Prince Makade before the investigation committee. Lord, those are the submissions in relation to res judicata. Then just a couple of particular points that arose. There was a reference. There was a brief affidavit that was attached to the President's heads of argument by Prince Makade in the will proceedings. Your Lordship will find it at the back of the heads of argument, and reference was made to it by my learned friend. Quickly, the submissions in that regard, if we look at the case number, it is not the case number of the Imbonisi application. It relates to the will application. Prince Makadi is not one of the main parties. He is indirectly joined through the shotgun that's fired at the royal family, if I can put it that way, the sixth respondent, the generic persons in Annexure A. It is a brief confirmatory affidavit. As appears from paragraph 2 of the affidavit, he participates solely on the basis that he is a beneficiary of the will and or a royal family member. He does not engage in any way whatsoever on issues pertaining to the traditional leadership dispute. The only issue of substance that he refers to is the validity of the will of the late Isilo. And that he does briefly at paragraph 6. And in a way, by doing so, confirms that as far as his participation is concerned, it had nothing to do with the traditional leadership dispute. And in fact, if anything, that affidavit confirms that res judicata does not apply against Prince Makadi. Lord, my learned friend for the President suggested that we were making an argument based on Audi, or procedural fairness in front of the President. Lord, he is correct in saying that we do advance a case based on an entitlement to a hearing before the President, but our submission would be that what one is doing in that situation is giving a hearing through the committee. It's section 3, subsection 5 of PAJA says the following: where an administrator is empowered by any empowering provision to follow a procedure which is fair but different from the provisions of subsection 2, the administrator may act in accordance with that different procedure. Indeed. Indeed, Lord. That's the way the legislature has channeled Audi, and we're completely comfortable, if he had done that, that the necessary Audi would have been provided. But of course, if he fails to do it, then Audi has been breached. Lord, the 11th of May letter. Lord, in relation to... Indeed. Indeed, my Lord. In relation to that letter, we say that the chronology is particularly important. And if one looks at the sequence of events, the starting point perhaps is the Queen's letter to Prince Buthelezi and the royal family of the 23rd of March 2021, which my learned friend for the President read out, in which she effectively nominated his brother, Prince Misuzulu, as the person that she proposed for identification. It's very likely that that would have come to the attention of Prince Makadi. They come from the same palace, they're brothers, and that's something that would have, on the probabilities, have come to his attention. In other words, that his own mother had effectively dropped him. On the 5th of May, Prince Makadi is identified and reliance was placed on that meeting. But my learned friends submit, and there's some support for that, that it was a secret meeting. What's clear on the founding affidavit is that Prince Makadi was not there, and therefore could not have known what went on there. On the 7th of May, there is a meeting, and his mother's will is read out, purportedly again identifying Prince Misuzulu, following the reading of the will, and that's where Prince Buthelezi said that the succession debate was now closed. There's a striking out application in respect to these, my Lord, but I've already explained why, 5th of May, what the explanation is. But these are all issues that came through the media. So obviously he would have been hearing what was happening in the media, and what is happening in the media is what's impacting on his mind and how he's following the developments. So 7th of May, Prince Buthelezi says that the debate is closed. 8th of May, Prince Buthelezi announces to the media that the matter of succession has been settled with the reading of the will, and quotes, "The king is already on the throne." 9th of May, the Premier visits Kangela Makengane, palace to which he belongs, to pay homage to the newly announced king, and brought cattle with them, which he presented to Prince Misuzulu. The 10th of May, the Premier's spokesperson is quoted by the media as having said that the Premier will announce the date for the coronation of King Misuzulu. He's being pestered by the media. So on the 11th of May, he sends that letter, in which he says, "Get these people off my back. Die kool is deur die kerk. Accept that what's history is history. Had I been nominated, I would have accepted. And, my Lord, the suggestion that the words "at least not in the form that it was" is an admission that there was a renunciation is, with respect, quite wrong. It is saying that he would have put his letter, he would not have put his letter in the past tense. He would have said, instead of the past tense, had I been nominated, I would have accepted. He would have said, if I am nominated, I will accept. That's how he would have put his letter if he wanted to get the press off his back and to get Prince Buthelezzi's assistance in doing so. And Lord, there's nothing wrong with his explanation. It's contextually and chronologically appropriate and sensible. Lord, there was also a suggestion dealt with to some extent by my learned friend, Mr. Masuku, relating to this identification meeting being a ritualistic process. We also don't agree with that. I don't think we agree on the same basis, because there's a lot of common ground between us and Prince Misuzulu about the Great Wife as being the palace from which the king comes. But we wouldn't say it's a ritualistic identification process. Firstly, it's constitutionally problematic to say that an identification decision that's statutorily provided for would be dealt with in a mindless, ritualistic kind of way. But secondly, there are serious issues to be discussed, like the issue of Ukufakwa, which never got to be discussed at the meeting of the 14th of May. That should have been discussed. That needs to be the kind of thing that has to be considered. There's statutory provisions that have to be considered at the identification meeting. My understanding, and I think it's somewhere in our papers, is that if a candidate has conducted themselves in some particularly unacceptable fashion at stages in their lives, they might exclude themselves on that basis too. That kind of thing might also have to be considered. Lord, then there is reliance placed by the second respondent on an affidavit that, as I understood the submission, was said to come from the Imbonisi record and as having been put there by Prince Imbonisi or their legal team. And it was an affidavit, they say they rely on, signed affidavit by Chief Buthelezi. Now, if that was the submission, that suggestion was incorrect. That affidavit was not included in the Imbonisi application by Prince Imbonisi's legal team. It is part of the first set of late supplementary material that comes annexed to the second respondent's supplementary affidavit that came through on the 6th of September. It's one of the
Was the point not was that signed affidavit by the late Prime Minister before Madon Duete? Wasn't that the point?
I didn't understand it that way, and it couldn't have been because it comes. I think it comes too late in time. I think it's a July 2022 piece of litigation. So that affidavit is subject expressly to our second strikeout application, and there is severe prejudice if that affidavit is allowed in, to the extent that all these affidavits remain relevant. As your Lordship has pointed down, there's an element of narrowing that's come with the focus of dropping the challenge to the identification decision. And it may well be that when one starts to hunt through that mountain of information, there's very little of it that remains relevant to the dispute. But that's an additional reason with respect to keep it out. But if there, I can't even remember what's in there, to be frank. But if there's stuff there that's prejudicial, because it's a long affidavit by Chief Buthelezi, it really does need to stay out. Particularly because that application was never ever served on us. There we are not a party. What happened there is there is again the sort of ritualistic, the royal family members in Annexure A. But if you look at the service provisions in the notice of motion, and I'll give your Lordship the references, there was no provision for service on anybody from the royal family members in Annexure A. At that stage, we were on record in correspondence. My attorney was never contacted about that. We simply weren't a party. So no chance to reply in the litigation and no chance to reply in this litigation. And, my Lord, the page references there, this affidavit is also to be found in Simakade because identical affidavits were put in late in both applications. It's KM11 at 056-153. And your Lordship will also see from page 056-159 that it's a completely different Gauteng case number. Lord, briefly, it seems that there is still an attempt to get the unsigned affidavit of Chief Buthelezi onto the record. I've already made submissions as far as that's concerned. I won't bore the court with going through each of the requirements in section 31C of the Law of Evidence Amendment Act, but we say it just doesn't cut it as far as that's concerned. And the only submission I'd make in that regard is your Lordship will recall that in the postponement application, Prince Makade chose not to explain why he wasn't willing to sign and said, I will do so at the appropriate time. Well, he still hasn't done so. He didn't explain it. He didn't explain it at the appropriate time. He hasn't given a full explanation, and all the more reason. But the main problem is just we've never, ever had a chance to answer it. And in those circumstances, it really can't be used against us, no matter what the justification of the reasons that were given. But finally, in relation to costs, Lord, on the basis of BioWatch, this is constitutional litigation. So on the basis of BioWatch, if your Lordship finds in our favour on the basis of the amended order put up, we've been substantially successful, and BioWatch determines conclusively that the President and the Minister must pay our costs, including the costs to counsel. With respect to the only issue for debate is the costs order that we sought against second respondent on the party and party scale in these proceedings. What BioWatch says about third parties, as it were, or private parties in constitutional litigation, is that ordinarily, as between them, each party pays their own costs. We made a submission that they infringed the part of BioWatch that says if you're ill-disciplined in the litigation, then you can end up with a cost order. We persist in that submission, but it's within your Lordship's discretion to make a decision as far as that's concerned, and obviously we respect that. Those are the submissions in reply, Lord. And I believe I'm exactly on 1 o'clock, Lord.
Lord, a learned friend handed to amended draft order. Is that why you took instructions on understanding down after the hearing? I haven't been able to take instructions. No, I was taking instructions on other issues. Haven't been able to take instructions on this. And what's more is I haven't had time to examine the affidavits to see whether there is a basis, for instance, for paragraph 1. Let me also add, my Lord, that the Malutsi case was uploaded, I believe, at 9:45 this morning. It was not referred to in opening argument. I would like time to examine it. I'm not going to suggest that we do it now. I'm going to ask your Lordship to allow me to submit short heads on the draft order and the Malutsi case. And we'll do that within a few days. Then I simply want to give your Lordship some references. That's all. Notice of motion 056-235, paragraph 4. Now, this is in the Mbonisi application. My learned friend didn't read this to your Lordship. I'm not suggesting he did so deliberately. He couldn't read it all. Founding affidavit 056-246, para 8.3. That is the paragraph which is, we say, a permanent interdicting the President. But your Lordship will read it for yourself. And we have found where Judge Madondo referred to the issues, including that paragraph 4, which said if the third respondent has completed everything, there is a interdict in perpetuity against the President. That's where you'll find it. Then, my Lord, the heads of argument, the compendious heads of argument filed before Judge Madonda, there were compendious heads for all three applications by Mr. Modinsela, 059-116, paragraphs 133.4, 137.7. Under that 059-119, para 140, and 059-123, and following. And you will see where the issues and the real disputes arise before Madondo AJP.
Suggestion of short.
No objection, Lord. We obviously weren't in argument referred to these references. Subject to the same constraint, we might have something short to say, but I doubt it.
All right. In fairness, then, I'm opening myself to being burdened by yet further papers.
Shall I withdraw that?
I shall grant the parties then the opportunity of dealing with the amended draft order presented this morning and the cases uploaded this morning, and parties will do so in writing to be uploaded. Shall we say when? Next week? Friday?
Perhaps Monday. With respect, Lord, the longer you give us, the longer we'll make them.
Thank you for that.
We're aware of that in Mr. Dobson's case. However, we should try and do it timelessly. I think Monday will be fine.
We agree with Monday, my Lord. We're
Monday, that will be then the 23rd.
indeed, Lord.
Lord, that will put us under some pressure, particularly because there's another application which has been brought, which requires answering affidavits. Now, it's not been brought in this jurisdiction, but it's been brought in what we...
Might require your attention.
Absolutely. I think Your Lordship's original proposal will...
Subject to the caveat that if I give longer time, it doesn't mean the heads get longer. It's just means that you have longer time to do so.
Yeah.
Let's make it then, I hear parties are making it on Monday, but let's make it then next Friday.
As
That
well.
will be then the 27th.
24, 25. Indeed, my Lord. Lord,
Shall we just include those in writing?
I made note of
Thank you, thank you.
Lord, may I propose that we have a page limit, because if there isn't a page limit, the discipline of a page limit imposed on all of us, say perhaps something like 10 pages maximum.
I will rely on senior counsel when they say short.
As the court pleases. As the court
I'm
pleases.
not going to receive 5 days if Mr. McGraw runs into 5.5 pages. What am I going to do? Draw the last page?
As the court pleases.
My Lord, I'm not so sure whether this shouldn't have been staggered, because we would like to hear what the submissions in relation to the draft order say before we can respond. Just in case we decide.
This matter quite complete, and you've now had the draft. I would expect then each party submission from the amended draft.
No, it's fine. If that's your direction, I thought.
Direct now one party first, then another party answers, and then a reply. You must not have a re-argument of that.
It's not a suggestion for a argument. It's a suggestion that we understand, just in case we don't have to put any submissions. if we don't have to put the submissions you are proposing. All I was suggesting is that if we get to hear what the other side says, then we don't have to. That's fine.
And I don't deprive anybody. I hear what you say. If someone's disadvantages, if you file yours and the fees are reasonable, then I would say.
That's fine. I was suggesting order, but if the duplication is okay with you, that's fine. I prefer my mechanism, but you prefer that. Yeah. Thank you.
Having said that, in regard to the interest in the matter and the importance of the matter to the kingdom and the monarchy, the AmaZulu people and indeed all parties to this litigation are entitled to a proper consideration of the matter. This will include a deep and intensive reflection of all the evidence placed before the court, as well as the consideration of the arguments presented, both written, for which I thank the practitioners, and oral, for which I thank those practitioners who presented oral arguments. The result of that is then that judgment will be reserved until a later date.
As the court pleases. When the judge should never speak when all counsel is sitting. Yeah, so